Hello everyone. We are getting the hang of Ask Andrew. Our production people are learning that it takes a few seconds to get up and running on the internet. Even though we start at 8 o'clock, our audience needs to click on a link to start watching the show. You may also want to get a tea or coffee, put your computer or iPad in a good spot, adjust your headset, and maybe put your feet up. And that takes a little bit of airtime and means the official start of Ask Andrew, January, is just seconds away. Good evening, ladies and gentlemen. I'm Andrew Feldstein. I'm the founder of Feldstein Family Law Group, and I'm the Andrew in Ask Andrew. I believe Ask Andrew is the first internet phone-in show created by a family law lawyer. I'm here to answer your questions. I will give you lots of legal information for free. I know there are lots of questions about separation and divorce. Tonight, I'm in my own office in Markham, Ontario, just north of Toronto. Feldstein Family Law Group has other offices in Vaughan, Mississauga, and the Bloor West Village area of Toronto. Our newest office is in Oakville, which we opened in July of last year. And that means, of course, that Ask Andrew will be most useful for people in Ontario, and because of the national nature of the Divorce Act, most of the rest of Canada. Our firm has 10 family law lawyers, including me, and we practice family law exclusively. Our goal is to get the best deal possible for our clients, one that is legally binding and won't come back to haunt you, one that lets our clients get on with their lives instead of fighting for years. We understand that the work we do impacts our clients for years to come. We get that, and we take our work very seriously. All combined, our lawyers have decades of experience. This means that we can suggest options to clients that they may not have thought of. Our lawyers meet with each other often to discuss our cases in confidence. We share knowledge among our lawyers in confidential and regular meetings. Here's how tonight's question and answer show works. We have already received some questions and we welcome more tonight. You can phone, which means we can discuss your situation. All you have to do is call 1-800-498-3486, as you can see on the screen next to me. One of our staff will answer your call, ask the general nature of your question, perhaps help you phrase it, and decide on whether you wish to use your real name. You can send us a text at 289-301-7090, also on the screen. Lastly, you can send me an email at andrew@feldsteinfamilylaw.com, as you can see right there. There are some technical things you should know about. Each Ask Andrew show is recorded by YouTube, and you'll be able to go back and watch the show anytime you want. It also means that your question will be around for a long time. So it's a good idea to phrase your question carefully, and not ask a question in such a way that it can identify you. There's a delay in the time between when we speak and when the words come out of your computer speakers. If you are one of our callers, our telephone conversation will seem normal with no delay. But please turn down your computer speakers. We need to turn down your speakers to avoid the high-pitched, squeaky speaker noise. So let's get started. Please press the button and call our office. Now, we've had some texts and emails that have come into our office before the show, so we're going to start with those. The first one is from a gentleman, and he had 3 questions for me, and I'm going to start with the first one. Does one spouse have any legal financial advantage over the other if they serve the separation agreement or divorce papers first? The practical answer is no. First of all, you're not serving the separation papers. You might be sending a letter, or if you send an agreement is just that. It's something that both sides have to agree on. Some people will believe it may be an advantage to actually start the court process first in an application for divorce. In some cases, and I would say it's very few, there may be a very small technical advantage. In most cases, I wouldn't worry about rushing to get started. I think I would recommend to people it is better that you focus on resolution, because resolution is better for the family than litigating unless you absolutely have to. The second question from this gentleman was, is it any significance under law which spouse leaves the home? If so, In what way and under what circumstance? And this actually is a really good question because it's one of the questions I frequently have people asking me. And there's really, in my view, two significant reasons why. Number one, if you have children and you leave, you may not have a schedule of when you're going to see your children. And the spouse who's staying in the home may make it very difficult for you to have that time period when you can see your kids. And then as you get further along the process, they're going to say that the status quo, which the court will give weight to, lies with the particular person that has had the children and in the home. The second piece of that question just has to do with the practical reality. You have a lot of equity tied up in your home. It's usually your greatest asset. And if you move out of the home, the person who's in there may like the fact that the mortgage is significantly lower because they're tying up your equity in the home. So they may be very happy continuing on that way. So I always suggest to people that the smartest move is, regrettably, not to move out of the home unless they have an agreement, and don't just vacate the home. Now there's a caller on the phone right now. Hi, this is Andrew. How can I help you?
Oh, hi, Andrew. I have kind of a complicated question here.
Okay.
I've been in a long-term marriage. I have given up my career in order to support my spouse's career with a move to the United States. I have not worked in the last 17 years. My husband filed for divorce in the state in which we reside in June of this year.
Okay, so am I correct that you were living in the United States when you separated?
Yes.
Okay.
However, where it gets complicated is we have another residence in Ontario where I have been probably living the majority of the time over the last couple of years due to extensive renovations that I was overseeing. And I gave up the matrimonial home in the state in which we live in order to give him that home, and I've been living here since probably July.
Okay.
The divorce was filed in June of this year. We will have been legally separated since February of 2015. Currently, our next court date isn't until middle of June.
Okay, so the problem you're facing, if I'm correct, where is your court action taking place? In the U.S.?
Taking place in the U.S.
Okay, so as you may guess, I'm a lawyer here in Ontario. And even if you're from Canada, courts will deal with matters based on, for property purposes, it's habitual residence, which is where you were living on the date of separation. For kids, dealing with custody and access, it would be where you were living on the date of separation. The only issue is if you would have lived in Ontario for 1 year post-separation, you could be eligible to seek a divorce here in Canada. But if you haven't lived here for the last year, you can't even commence an application here for divorce.
Well, like I said, over the last 2 years, I've been living in the majority of the time in Ontario related to obligations that I was overseeing here in Ontario. I do have a residence here that I have my actual name on.
It's not about having a residence, it's a question of where you've been living. If you've been living here for the past year, then you could commence an application for divorce here and seek spousal support, but then you have two competing jurisdictions. And the realistic point is that only one jurisdiction can be paramount. And if he's already started his action in the United States and you haven't started it here, you would face a very significant uphill battle for a court to take jurisdiction here. Because property laws would be based on the U.S. How old are your kids, if you have any?
They're adults.
They're adults. So part of the unfortunate reality is you'll be most likely under the laws of spousal support in the state you were living in. And most of the time, spousal support in Canada is more generous than in the U.S., and you would rather be in Canada.
Correct.
You could try to start an application for divorce here, and I suspect that your husband will say that this is the wrong jurisdiction And that's all he would say in these materials, and ask for the action to be stayed because it's the wrong place. And my gut feeling is he'd probably be right, because there's a lot of weight given to the fact that A, he started the action first, and B, most of the evidence that would be needed for your litigation would be in the state that he lived in. On a balance of convenience, it's probably more convenient to deal with it in the U.S. And he may even argue that you're not here more than half the year and that your residence is really in the U.S., albeit you can have two residences. Does that help? You may not like my answer, but is that what you were trying to understand?
I understand that. However, it will be a year of separation come February, and before the next hearing for the judge will be a year of me living more in Canada than the U.S. So
I understand that, but the point is he's already commenced the action in the U.S. before you did here in Canada. And on a balance of convenience, I would think if you're making a claim for spousal support, most of the evidence would be there. Under Canadian law, if you gave up your job and you moved to a different part of Canada, it's certainly a very good argument for compensatory spousal support. And in Canada, once you're able to establish that you're entitled to spousal support, then you would look at the spousal support advisory guidelines in order to understand what amount he should be paying, because that would generate a range of a low, mid, and high number. But as I said, my gut feeling is I think you're in whatever state you were living in. Whatever court that's dealing with it, I think is probably going to be the right court. And if you commenced here, he's going to object to you commencing here.
well, I have proof that his plan was to move back to Ontario in 2013.
Yeah, but he didn't move back.
Yes, but I feel that I have been going by everything that he has wanted to do, and I feel that given the I have given up my career and at my age, which is
But you see, those aren't arguments about what the right jurisdiction is. That's an argument for your claim for spousal support in court.
but there is no spousal support in the state in which we reside, and that's where I believe that I have been kept there because of that.
Okay. Well, if that's the case, you can try an application for divorce here. I think it may be a stretch that you're going to get it, but then try it. My gut feeling is the right jurisdiction is in the U.S. and not here. And one of the problems is once you're divorced in the U.S., you can never make a claim for spousal support here.
I understand that. That's why I was wanting to know, since there's such a period of time now in order to...
You don't have to wait 1 year to commence your application for divorce. You have to be living in Canada for 1 year. Even if you're less than the 1 year, you can commence the application, and a court will not grant the divorce until you've been living separate and apart for at least a year. But you can actually commence the application 2 days after you separate. So you can try it. I wouldn't be optimistic that you're going to be successful, but you can try it. And I understand. What state do you live in?
Indiana.
Indiana. Okay. And I mean, I obviously can't speak to Indiana law, but it's unfortunate if you've been told that in Indiana they don't have any spousal support. And you have a lawyer in Indiana?
Pardon me?
You have a family law lawyer in Indiana?
Yes, I do.
Okay. So I obviously am sympathetic to your frustration, but you still have to go through a certain legal analysis in order to understand that. And he may have asked you to move to Indiana knowing full well that he's going to do better. But that's where you were living.
It was to be a short-term assignment, but I agreed on the move. And
I understand that. We all make decisions, from getting married and decisions during the marriage, and it takes us down a road quite frequently that we're not happy about later on. And I get that. But can't change what the law is. And have you spoken to any lawyers in Ontario?
I actually spoke to a family law judge.
Okay. Well, I'm not going to ask his name
No,
or her
I won't
name,
give it.
but they probably had a similar view as mine and said, if you want to take a shot at it, you can take a shot at it, but it's a hard case.
Even though we're both Canadian citizens?
Yeah, because citizenship is not what counts.
And we are both married in Ontario.
And that doesn't count either.
And we've had a residence which we spend half the time at in Ontario.
That's the argument, is you would have to be able to establish to the court that you spent enough time here in Ontario to make this the place that would be the proper jurisdiction.
Do you think that my records of border crossings between Canada and the U.S. would give proof of establishing that?
I think that's good evidence, but you need both of you, not just you being here. And then you face the second problem of the fact that he's already started the action there. But I would try and, if you can establish that you both were living here, and in essence you had two places that you were living, because there's cases where they say there's two habitual residences, then you want to try and get an order for support flowing here before the order is made in the U.S. But I would expect he's going to say that was just you coming here, not him. And then there's a question of how you dealt with it in the U.S. and whether you were torn to that jurisdiction or not. So there's a lot of questions, and it's not an easy case. Doesn't mean you shouldn't necessarily do it, but don't think it's an easy case and it's not a slam dunk.
So do you think that I should try and put an application in, and
well,
when would you?
I think what you should do is you should consult with a lawyer who does family law. If you want to call my office tomorrow to schedule an appointment, I'd be happy to meet with you. But I'd want to see what the court materials look like in the U.S. and whether you were torn to that jurisdiction. And I'd want to go through in detail the facts surrounding where your residence was and the movements of both you and your husband. Because it's going to be a pretty detailed analysis, and I would expect that there's going to be some real opposition to that claim. And before you go commence the application and expose you, if you lose, you have to pay his costs. You want to make sure you're on somewhat solid ground.
Okay, I did send you an email with more in-depth information.
Okay.
And that was on January the 22nd when I sent that. So.
Okay, I remember reading that, and you said you wanted to call into the show. So now I can recognize that it's the same person.
Right.
Okay, I hope that helps you. I'm sure I've given you some things to think about, and if you want to call our office to schedule an initial consultation, please do.
Okay, thank you very much.
Okay, have a good night. And interestingly enough, that's one of the strange ironies in family law, which is if you are divorced in another jurisdiction, you can never make a claim for spousal support in Ontario. That becomes very important because in Canada, as I said earlier, spousal support is more generous than most U.S. states. As a strategy, one of the things I always do when there's a jurisdictional issue, and it's early on in the case, not when there's already an action going on in another jurisdiction, I like to say to my clients, you should be hiring a lawyer in both jurisdictions so we can have a discussion and we can understand what your potential rights and obligations are in both jurisdictions. Because sometimes a client will call me and say, I want this to proceed in Ontario. And I may end up telling the client, well, let me speak to a lawyer in another U.S., if it's in the U.S. or in another jurisdiction in Canada, and I want to have a chat. And I want to look at, in my opinion, where is the case going to end, and where in the opinion of the lawyer in the other jurisdiction the case will end. Because sometimes you're about to fight that Ontario is the right place, and you end up telling the client, well, if they're saying it's the other location, you're going to do better there. So let them have it there. So these are things you really have to consider, and these interjurisdictional cases from the academic perspective can be very interesting, and there's a lot of strategy that's involved. And in some cases, it's also about speed and being the first one to go to court. Now, I'd like to go back to the questions I was going through before, because I had done 2 of the 3 questions that that gentleman had sent in via email before the show. And his third question was, has there been any settlements that have taken into consideration that the spouse that left had obtained legal or other professional coaching prior to a final disagreement being triggered, that rather than trying to diffuse the situation actually contributed to it occurring to reach a particular outcome. Example, a spouse making virtually no effort to work out the problems in the marriage and instead leading to a breakdown in the marriage. And this is an interesting question. And the reality is we live in a place in Canada that has no-fault divorce. That means a court doesn't go through the inquiry of trying to say somebody was right or somebody was wrong. A lot of clients will say to me, Andrew, that doesn't seem right. I wanted to save the marriage. I wanted to have a family stay together. I thought that would be better for our kids, and my other spouse didn't want any of that. So they should have to pay a price for making that decision. The problem with that theory is legal fees are expensive enough. We have lots of things in family law we can fight about, and trying to get into a fight over the fault of divorce will only add conflict and cost to the legal proceeding. So hence, we don't deal with it. It's not really an issue other than trying to understand the motivation of both sides in terms of resolution. And I say that because as a lawyer, if I know that my client or the other side has a lot of anger and is very upset with my client, I appreciate that that's going to make it more challenging for that person to be ready to settle. And that's an obstacle I'm going to have to get over. However, it's not a reason that a judge is going to say one side should get more spousal support or more child support or an unequal division of net family property unless, and this is a small caveat, unless somebody spent a lot of money. As an example, someone is having an affair and they drop a few $100,000 on the person they're having their affair with. Well, that may be grounds to say I should have an unequal division of net family property because my spouse shouldn't have to, in essence, cover half of what I spent on, if that was me, my mistress. But other than that, it really isn't relevant. And that's something people really do struggle to appreciate and accept, because if they've been the person who perceives themselves as the victim, taking the example of the other side cheated, they feel wronged. They feel hurt. And there is a ground for divorce of adultery. I've seen it used in my 22 years on 2 occasions. And quite frankly, not worth the money. The only other time wrongful conduct can be relevant isn't for getting more money or getting the divorce earlier. It's about the children. If somebody is never at home, whether it be for work or for having a significant other in their life that shouldn't be there, a court can look at it and say, what was the status quo regarding the parenting of the children prior to separation? And if one person was always home and the other person was busy out all the time and never around the kids, well, that's going to make it harder for that person to suggest they want to be the primary caregiver for the children or even shared. It creates an additional challenge. So there can be some consequences, but it's in very specific circumstances. Now, one of the texts that we received is the following. She's got a bachelor degree and works on her own business with limited income. She has no interest to find a professional job based on her past experience. What's the best practice to apply reasonable imputed income to calculate the spousal support? Is that possible to apply at least minimal wage as imputed income? Thanks. So the further along you are in the process, the more you may understand about this question. And this has to do with, obviously, spousal support. And in terms of spousal support, we have to determine what each side's income is. So you take a scenario, in this case, it's obviously a text from a man. And the man is saying, my wife is not earning enough income because she's not working that hard and she doesn't have any interest in working hard. And when that happens, you can go to court and say, this person has failed in their obligation to work towards self-sufficiency as required in the Divorce Act. And you can ask a judge to impute an income to that person. When they say, can you impute a minimum wage? Usually the answer to that is yes, depending on child care requirements or other requirements in the person's life. Sometimes the argument is they're capable of earning a lot more money. You take an example of someone who was, call them a lawyer, and they haven't worked in the last 3 years of the marriage. Now they separate and they say they don't want to go back to work. Well, the payor spouse is going to say, you have skills that can earn considerable income and you should go to work. And they would go to a judge and say, well, 3 years ago they were making, say, $75,000 a year, and judge, you should impute them back to that $75,000. That becomes important because if there is entitlement for spousal support, the spousal support would be based on the payor's income and the recipient's imputed income. And if the recipient is imputed to the $75,000 example, that's going to reduce the spousal support obligation of the payor significantly. So we have a lot of cases where we do fight about what's the right income and whether income should be imputed. It's a very common issue. And here's another text. I have a few questions on separation date and asset equalization. My husband insisted that his separation date was June 30th, 2010 as a compromise. His lawyer suggested another date in 2015 as a separation date instead of using the 2010 date. A, does the 6-year time limit for asset equalization apply based on the 2010 date? And B, what will happen if the case is not settled by June 30th, 2016? Very smart question. And this is because if you want to make a claim for equalization of net family property, there are 3 limitation dates. And a limitation date is a deadline in which you must commence your claim in court, having your application issued, or else you may lose the ability to make that claim. For equalization of net family property, it's 6 years from the date of separation, 2 years from the divorce, or 6 months after death. And it's the earliest of those 3 dates. So in this case, this gentleman is saying, or this lady is saying, I should say, that her husband is saying it's June 30th, 2010. That would mean she should commence her application by June 30th, 2016 in the event that they have not resolved their matter. She should not rely on the fact that she's arguing it's a date of separation 5 years later. She should still put in her court material that the date of separation was in 2015, but at the very least, if she does that, he can't argue that she missed the limitation date. I know if I was the lawyer in this, I'd start being nervous because I'm always worried about limitation dates, and I'd want to make sure that I got that court action issued so I've met the limitation period. The other interesting point that I should add is that family law is the only area of law I know where you can actually ask a court to exercise their discretion to extend the limitation period. However, I would suggest to anyone, don't rely on a court exercising their discretion to extend the limitation period because they may go either way. They may extend the limitation period or they may not. You're sitting here, it's almost February, you have about 5 months. I would either want to settle the case very shortly or get the application commenced. I'm also always nervous that has your husband, this is to the person who sent the text, put in writing on a with prejudice basis that they say the date of separation is June 30th, 2010. Just because they've told you that verbally doesn't mean that they may not say that you actually separated it in January of 2010 once you commence a court application so that they can argue you missed the limitation period. So you have to realize it's not just what they verbally told you, but have they put it in writing on a with prejudice basis so you know it really is June 30th, 2010. Otherwise, I would want to get this going within days. The next part of the same text from this lady is her husband has a personal account on the asset list. Can she request all statements for his personal and bank accounts? He's in a foreign country, and can I request to see his personal tax returns? We are in a world that there's full and frank financial disclosure needs to be provided in order to work towards resolution of a matter. You can't resolve it without it. That means if you want to see the bank statements, you'll get to see it. Tax returns, in fact, must be attached to the sworn financial statement that's being exchanged. To me, I don't know how you make a deal without having tax returns. And if you want to see the bank statements, ask for them and you should get them. The third question from this lady is that she has a strong suspicion that her husband is hiding assets from her. Can she hire our firm to do the discovery only? And some of you may have been on our website, familylawhelp.ca, and that's all about unbundled legal services. What that means is there's two types of way of representing clients. One is called the comprehensive retainer, and that means we do everything for a client. Another way is a limited scope retainer, and that's where the client can say, we don't want you to do everything in the comprehensive retainer, and we're going to ask you to do certain specific tasks within the process. And the answer to that is, yes, we can. And that can really take a form or shape that we can work out together. It can mean we go to court and you draft the materials. It can mean we draft the materials and you go to court. It can mean that you may want our help with respect to disclosure and questioning if necessary, and then you take over again, and then we're there to help you when you need help. It can even be as simple as you want to phone us to give you coaching before you go to court, or a mediation, and provide you with the information and tools that you need. So it really can be almost anything. The next text that we received was about spousal support. And this couple says, we are in the mid-60s and have a long 40-year marriage, and that is long term. He is to pay me support since I don't work and I'm not earning income. He is, however, retiring in a year. How is support to be determined? I am told I may not be entitled to much. Well, we have to look at the age and the planned retirement date. If you're both in the mid-60s and he's had a long-term plan to retire at this age, a court would probably say that's okay for the retirement. However, if he's retiring just because you're separating and he doesn't want to pay you support, that may be a problem. The caveat to that is the payor doesn't have to work until they're in a grave. People are entitled to retire, but the question is, what's the right retirement age? If this payor was 50 years old saying they want to retire, that would be a problem. In this day and age, is 63 an appropriate age, 65, 70? There is no clear-cut answer for retirement. Retirement has to be looked at on a case-by-case basis. If this individual who's retiring was in a profession where everybody retires at 65 and their pension kicks in, then that's what's going to happen. Then how the case is going to be looked at is very different. There's going to be a calculation of equalization of net family property. And if all the assets have been equalized and both parties have the same assets to generate income, then it means that your husband in this scenario doesn't have any more money than you have and probably doesn't have any more income than you have. In that scenario, you won't get any spousal support. It's a question of whether he's going to be working. The next text that we received is the following. My ex-wife changed the locks on our house the day we separated in May 2011 and continues to deny me access. We are no further ahead than the day we separated. He says that if it will go to court, it will take years. We've had similar incomes, pensions, all assets jointly owned, 4 grown children, no dependents. How do I get the process moving again and access my house and other assets before I'm bankrupt? Taxes and other joint responsibilities without providing a portion. I'm barely able to pay my own rent. My lawyer has sent over 50 letters. Well, there's the problem. 50 letters doesn't do anything. They're obviously ignoring all the letters. It is the correct strategy to start off with writing letters and hopefully get the negotiation moving. But you have adult, independent children, so there's no reason that he needs exclusive possession of the home. You've been waiting now almost 5 years to have him sell the house. It's time that that stops. You need to commence an application for divorce and ask for the sale of the home. You're a joint owner. You're entitled to the sale of the home. You can bring a motion for summary judgment on the facts you've told me. You should probably be able to win that motion. And I would do it without hesitation. After 50 letters, just go to court. There's a time for it. This is the time. He's obviously not moving forward with it. This will solve the problem and end the impasse. If this individual appreciates that you're being serious, then you probably will get to the resolution that you want. But unless you go to court, you're going to continue on in the same fashion. The fifth text that I received before the show is the following. Is tax on RRSPS at 20% applicable on an equalization NFP statement? So that sounds like somebody who is obviously working through the process, and the answer is maybe. there is no doubt that when you have an RSP, it's going to be withdrawn at some point in time and taxes will have to be paid. So therefore the question is, what's the right notional tax rate to take, because you're probably not cashing it in now? And that question can be hotly contested because there can be different rates. I have some clients that will say to me, well, Andrew, I'm in the top tax bracket, so it should be at 50%. It will never be at 50%. Doesn't happen unless you're immediately taking out the money. And there's two reasons why. Number one, if you're, say, I'll take the average male age at date of separation, 44 years old, you're probably going to be working another 20 some odd years. And while you're working, you're probably not going to cash in your RSPs. So the money you have is actually going to be invested in growing and growing and growing, and that's to your benefit. The second piece is that you're probably not going to cash in your RSPs while you're working because you don't want to pay at a high rate. You're probably going to cash in your RSPs when you're retired. That means your marginal tax rate is going to be much lower. And those two factors, if we did it technically the right way, would be hiring either an actuary or an accountant to come up with that rate. And when you do that, the rates are usually far lower than that 50%. And the magic is, what's the right rate? A lot of times we do use 20%. Sometimes we use 15. Sometimes you use 25 or 30. The older you are and the closer you are to retirement, the higher the rate. But 30% may be too high because that may not be your marginal rate unless your RSPs are of a very high value. So it's a good question, and they can be really all over the map in terms of the percentages. Usually the lowest I'll see is about 10 to 15%, and the highest I've seen can be 35, 40% if they're older and they have significant net worth that will generate significant income, or a pension prior to the RSPs that will create significant income. Now, before the show, I've gone through the texts I received. I also received a number of questions via email, and I'm going to start going through some of the email questions. I want to invite you to, again, either call us at 1-800-498-3486 if you'd like your questions answered on the phone. You can text us, as it says here, 289-301-7090, or email me at andrew@feldsteinfamilylaw.com. Now, the questions that I received before the show via email are as follows. We have two houses. How do we divide them? Mr. Feldstein, we are fortunate enough to have two homes. One is a regular single-family house in Toronto worth $1 million, and the other is a condo apartment in Florida worth about $600,000 US. Do we have to sell them both and divide the money? Can one of us live in Toronto and the other live in Florida and then switch several times a year? Between them, there are mortgages of about $350,000, but we could pay them off. And what happens with our cars? We have two nice cars in Toronto and one smaller car in Florida. These are all good questions. And I'm going to start with, if you're able to reach an agreement, it gives you the ability to fashion a compromise that a judge won't do. So if you want to work out, as you say, let's share both properties and move back and forth, and that's what the parties want to do, you can do that. I think that's very challenging as a separated couple. It may work in the short term, probably not in the long term when you have new partners who are coming into the picture. But that's something you have a choice to make, and you can try and work out a compromise. But if you're not able to work out a compromise, then if you go in front of a judge or a mediator or an arbitrator and you're asking them for their insight, they're going to fall back to the legal model. What does the legal model say about this? Well, the first question, do we have to sell them both and divide the money? Well, when we do equalization of net family property, we would put, if it's jointly owned assets, half on each of your side. The property here in Toronto would be very easy to get an order for the sale of the home, and it could be sold. The home in Florida is a little more challenging because that's a property in Florida. And technically, if you want to force a sale of it, you should go to the state of Florida to force a sale of it. But practically speaking, it makes sense to try and work out a deal. Either one of you buys it out or sell it on the open market. That's what would typically happen. Both of these properties would appear in the equalization calculation, as well as all their other assets. The same thing for the cars. And in this scenario, you could decide to say each of you keeps your car in Toronto, put the value on. One of you may keep Florida, or you both may decide to sell Florida. You both could decide to sell the property in Toronto and keep the property in Florida. These are things of crafting solutions, but, and this is a big but, the property in Toronto and homes when there are no kids, it's actually very easy to force the sale of a home when there are no kids. The next question is, I don't want my ex-wife's new husband to ever own my new house. My wife is having an affair, and I moved out of the house 3 months ago. Last week, her boyfriend moved in with her and our 2 children. We are arguing over who gets the house, and I'm okay with her and the kids living there, but is there any way I can get the separation agreement to say he's not allowed to live there? Can I forbid the boyfriend from staying overnight? Do things change if they get married? And I heard a story that says if she dies after she marries him, he will inherit the house. That's not fair to my biological kids. There's a lot of information and questions in there. So let's start at the beginning. If there's going to be a dispute about custody and access, there's no doubt that the wife choosing, whether it's an affair or not, to have someone move in, move in after the husband moves out 3 months ago, that's not in the best interests of the children. It's just not. That's confusing for the children, and the children should have some time to heal, and you even want to be cautious about introducing anyone 3 months after the separation to the children. So if there was a custody dispute going on, the husband would be in a better position because of this kind of mistake that the mother's making, because she's putting her interests ahead of that of the children. Now, he goes on to talk about their arguing over the house and he's okay if she lives there. You can't put in a separation agreement that prohibits him from living there. You could put in a separation agreement that would refer to the fact that there is a certain time period that neither party should be introducing any significant others to the children. So trying to control the home is wrong. Trying to do something that's in the best interest of your kids is fine. And that would mean that both of you would have to have an equal commitment, saying that it's in the best interest of the children that neither party will introduce a significant other to the children for 1 year after the parties separate, as an example, and that the relationship is of some permanence and the relationship has to have been going on for a certain period of time. That would be reasonable language if it's mutual and being done for the best interest of the children. That does not mean that you could keep that individual from being at your former home when the kids are with you. That's going to happen. There's nothing you can do about it. In terms of stopping him from being in the home on a permanent basis, well, this is your choice to make. As I've said before, you could at trial ask for the house to be sold, or on a motion. A motion's a maybe when there's kids who are in school, in a school catchment, a trial will probably be sold. And you can force the sale of the home. And the home will be sold. And your former wife will buy something else. And the kids and her new boyfriend will be living in that home. So you have to weigh the reality of how much that bothers you and look at your kids' interests and look at your own interests and put your kids' interests ahead of your own. And you have to decide what's best. But you are entitled to either have her buy you out or you can force the sale. But ultimately, you can't stop him in the long run. In the long run, he's going to be there. Whether they're married or not, if she wants him there, he will be there. Goes on to say, and I heard a story that says if she dies after she marries him, he will inherit the house. Well, if your wife has done a will, on marriage, the will be considered invalid, and she'll have to do a new will. And when she does that will, she should name who her beneficiaries are. Her new husband could, as I said earlier, there's a limitation period of 6 months, could elect under the limitation period to say he wants an equalization claim from your wife, and if they're living in that home, she would, and this is one of the anomalies in family law, if you own a matrimonial home on the date of marriage, then when you're doing your calculation of equalization in that family property that says it's your net worth on date of separation less your net worth on date of marriage, one of the exceptions to that rule is if you're still living in the matrimonial home that you owned on the date of marriage, you don't get credit for that. So in that case, if she died, she wouldn't get credit for that. And that would make what her estate would owe him significantly larger to the detriment of the children. So the best tactic to deal with that is having a marriage contract that gives her that deduction. That would be the best solution, but that's her decision. Your position can only be to argue that if your wife works, you want there to be security there for her child support obligations. And one of the things we as lawyers do is we calculate what that security ought to be, how much life insurance is needed based on her income. And if her income is nominal, it won't be much. So it's a question if she wants to do what's right for her children or not in terms of protecting that significant asset being the matrimonial home, or allowing it to be susceptible to her new spouse. The caveat to that is in law there's always an exception and an exception to the exception. If the time period that they're living together and they're married is less than 5 years, then in that claim after she passed on, defending the claim, her estate would argue it's a marriage less than 5 years, and that would include the common law period, and they would argue it would be unconscionable to equalize the net family property with the husband, and they may give him something less than half than his equalization payment, which would be half of the difference of their respective net family properties. I know that's a lot in that very straightforward question, but there's some complex issues there. The next question is, she drinks too much. My child is in danger. My wife always liked to go to bars and partied a lot on weekends before she got pregnant. She stayed away from liquor for a few months when she was pregnant and then started drinking more and more. The baby is 4 months old now. My wife drinks enough that I'd say she is a drunk a couple of days a week now. I don't want her driving with the baby or even by herself, and I don't want the baby raised by an alcoholic. My parents are in their 50s and would do a great job looking after my little girl during the day if I got divorced. But how likely is it the judge would give me custody, and does the judge have to approve my parents as caregivers? Well, it's obviously a very serious and scary issue if one of the parents is an alcoholic and they want to care for a child. The place that this gets into dispute is if you went to court, you're going to say my wife's an alcoholic, and she's most likely going to say, no, I'm not. I'm not an alcoholic. And then you're into the evidence of, is she an alcoholic? And one of the challenges there is just proving she's an alcoholic. If she's buying her alcohol with cash and not a credit card, you don't have all the purchases at the LCBO. If they're throwing out the bottles, you don't have that. She could accuse you of being an alcoholic. Testing for alcoholism is very difficult and challenging because it doesn't stay in the body for as long as various drugs. You can do random testing where she'll get a call and have to go to be tested to see whether or not there's blood in her, if there's alcohol in her bloodstream. But as I said, because it doesn't last long, it's going to take a fair bit. One strategy I have seen clients do, and it may sound really harsh, is when they know their spouse is getting in the car and driving drunk, they've called the police. And then the person's arrested, and depending on what they blew, it becomes rather obvious. I always remember one case, I was in court, and the other lawyer said, well, she's a great mother, other than the fact she drank too much that night. And the judge who looked at how high this woman blew said to the other lawyer, sir, that's not possible. Based on what she blew, she should not have been able to walk, never mind drive a car. The message I get from this is your client has a very, very serious drinking problem. And my client in that situation was able to get custody of his daughter because of that situation. And again, it boils down to the evidence and whether or not you can prove it. If you can prove it and this person is harmful, the court is going to want safety for the child. And that means if you become the primary caregiver, you're going to choose what the daycare is. In this case, you have parents in their 50s who can provide daycare. That's wonderful. It's also going to save the family money if you're not paying a third party for it. Now, the next question I have is, I don't want my children to leave Canada at Christmas holidays. I have 2 children, 4 and 7. They live with me and my parents and see their mother and grandparents every other weekend because my ex-wife lives with her parents. Mostly the visits go smoothly and there are no problems. But they want to take the children overseas at Christmas. I'll miss the kids at Christmas, but what really worries me is that some of our parents stay overseas and keep my children over there. Can I make sure the kids do not leave Canada? Will a judge make a ruling? This is a pretty common question that I get for people, especially as Canada has become a country with people who come from all different parts of the world. And there are cases that deal with looking at what's the likelihood of this person leaving the country. What are the things that a court would look at? Well, does a person who wants to take the children and go abroad, what are their connections to Ontario? Do they own real estate with significant value in Ontario? Do they have a good job here in Ontario? Have they listed their house for sale? Have they quit their job? Where does their family live? If a person has most of their family here, owns a home, and has a decent job, a court's going to be more likely to let them go to a jurisdiction where The Hague, that is a non-Hague signatory. The Hague is a convention on the return of abducted children. So for example, if someone abducts their children and goes to the US, there's a treaty that will say to the US court the children need to be returned to Ontario if that's where the child's habitual residence was, unless for very certain specific exceptions. And if it is a Hague country, it's easier to go to. If it's a non-Hague country, it's harder, and that's why a court will look at what are the ties to this community. You contrast that with someone who was in a tiny rental apartment, has no job, and their whole family is in another country, and that country is a non-signatory to The Hague. That's where you may say, I need to oppose that return of the child, because if I don't, I may never see my child again. So there's a lot of common sense, in essence, that goes into this. And you have to ask yourself the question, do I believe this person isn't going back? Because I've had clients say, take the child to a non-signatory of the Hague Convention because the person has all sorts of ties to the community. And in that case, the child gets to go on a vacation, but keep in mind, Christmas holidays are usually evenly split, and it doesn't mean they get to take the child for the entire break unless you coordinate some sort of accommodation that will give you more vacation time at a different time. The next question that I have is, I'd really like to be single again. I've been married for 3 years, and I've learned that my husband has turned out to be very different from the man I thought I was marrying. What I thought was laid back turns out, at least in my opinion, to be lazy. He was laid off and hasn't looked for work for a long time. I'm now the sole breadwinner. I come home and the house is a mess. He's done nothing all day, and he expects me to make dinner. And I'm bored when I come home and worried it's getting worse. What do I do first to end our marriage? Do I get forms from the government or call a lawyer or change the locks or what? What is the first thing I should do? Well, first of all, you can't change the locks if you're married. Both of you have equal rights to possession of the matrimonial home, and the locks on the matrimonial home cannot be changed. In this scenario, it sounds like it's a bad marriage. It sounds like you're not happy. You've only been married 3 years, and it sounds like you don't have any kids. If that's the case, then yes, you should get divorced. I would strongly recommend that you see a lawyer, at least call a firm like ours that does a free initial consultation, understand what your rights are, and develop a strategy of how you want to deal with your problem. It may very well be you're going to commence an application for divorce. You may have some spousal support obligations. Your argument would be that the court should impute some income to your husband because he's not seriously looking for work. You may have to pay some money, but the shorter the relationship, the better. When I talked earlier about the spousal support advisory guidelines, he first has to establish he's entitled to spousal support. You're going to argue he's not because he should be imputed to a higher income. And even if he is, the duration under the spousal support advisory guidelines, if there's no children, would be half a year to year for every year of the marriage. So if you're at a 3-year marriage and you did not live common law before that, your exposure is 1.5 to 3 years. Every day that you're there is extending the potential duration of the spousal support. That's the legal side of it. From a practical side, it sounds like you're miserable and you probably want to get out. And if you don't have kids, you can actually move on with your life and for the most part never have to deal with this individual. So if I were you, I would book the consultation as soon as possible. Now, the next question I received before the show is that divorce is confusing and much of the process makes no sense. I went to your separation.ca website. Much of the strife you and your lawyers write about in your blogs makes no sense to me. There's a grandmother going to court to see how she can see her granddaughter. I can't tell if that little girl's mother is mean and preventing a grandchild-to-grandmother relationship, or if grandmother's a bad influence. Regardless, they're hurting the little girl who seems to be a pawn in this scenario. A blog talked about one side hiring a child expert and the other side hired an expert to attack the first one without ever seeing the child. If you have time on your show, please talk about how common it is for this kind of nonsense to be part of a divorce. Unfortunately, divorce brings on all sorts of nonsense. But these kind of cases of grandparents' access typically happen in one of two scenarios. It's a scenario where it's still a married couple and one of them has a falling out with their parents, and one of their parents wants to see the child, and one of the grandparents wants to see the child, and the two parents feel that the child is a bad influence. The courts give a lot of discretion to the parents to make those kind of decisions. And it'll require some unique circumstances in order for the grandparent to be successful in the claim, because it's the parent's decision to choose what's in the best interest of the child, providing it's for legitimate reasons. Now, the second scenario of grandparents' access is when one of the parents had passed on. And the reason this is relevant and not in divorce, because if it's a divorce and both parents have time with the child, then it's up to that parent to have their parents see their grandchildren during their time, not during the other parent's time. So in the scenario one parent has died and the grandparent is being denied access, a court will have a lot more sympathy to that claim. And that may very well create a valid claim in order to establish a relationship between grandparent and child. Now, we're coming to close to the end of our January edition of Ask Andrew. It's been a great show. I'd like to thank the person who phoned in, and I wanted to thank those that sent us text messages and emails. Not only did you have interesting questions reflecting your own situation, but I know that many of the people in our internet broadcast audience found lessons for their own situations. We'll be back at the end of February with the next Ask Andrew show. January is a notable month for separation and divorce for the reason that we divorce lawyers see a spike in business. With the start of a new year comes New Year's resolutions to end a relationship that isn't working. People want to make a new life for themselves, and that's a good thing. I myself went through a divorce. It's now almost 3 years ago. So I know and I understand what you're going through. I understand the uncertainty and the anxiety that you feel. I can tell you I'm a type A personality, and as a type A personality, I like to be able to have a plan. I like to know where I'm going with my life. And when you're going through divorce, if you're a type A person, it's really stressful because you don't know what the end game is going to look like in terms of your relationship with your children. You're worried how often I'm going to see them. What is the home that I can provide for them going to look like? How will they suffer through the breakdown of the marriage? How you will feel about the failure of your own marriage and how you will feel that you failed your kids. You will feel tremendous insecurity financially, that you don't know where you're going to be at the end of the day financially. And that can be very unsettling as well. I do this for a living. I've been doing this for 22 years. Those were the kind of feelings and emotions that I experienced. And I know this business and I know it well and was able to calculate my scenario far better than most people could. And I still felt them. If I felt it, I can't imagine what a person who doesn't do this for a living feels. So please remember, if you have questions about family law, we have 3 websites that offer you a great deal of information, and you probably heard the saying, information is power. Separation.ca is the main Feldstein Family Law Group website. It has explanations of the process of working with us on a family law matter. Plus it has many articles and blogs, including videos that explain various aspects of family law. We have been working on this site for years. We have hundreds of web pages, and we work very hard to always have the latest information if the law changes. I'm very proud of this site, and I encourage you to inform yourself for free about your rights and obligations in separation and divorce. That's separation.ca. Another site is familylawhelp.ca. I mentioned it earlier. This site explains the entire divorce process and is designed to help visitors who might want unbundled family law services. Unbundling is a process where someone looking to get separated or divorced does some of the work themselves and asks a lawyer for help in other parts. An unbundled service client might, for instance, draft agreements explaining how they want a settlement to proceed and then pass it to a divorce lawyer for review. Or you might determine what points you want to make to a judge, but ask an experienced lawyer to actually stand up for you in a courtroom. That's familylawhelp.ca. And our third site is designed to effect change, to improve access to justice for all, those undergoing separation and divorce. Access to justice is the phrase we use when we talk about cutting the costs and cutting through the bureaucracy in family law. I have published 2 white papers, and we've received many comments about how they help build understanding on why costs are high and what can be done to reduce them. A 3rd paper about the difficulties of representing yourself in family court will be published this year. The site is called itstimeforjustice.ca. Thanks for tuning in tonight. Visit any of the websites or follow me on Twitter @Andrew Feldstein or on Facebook at Feldstein Family Law Group. Check our websites in mid-February to learn the day and time of our next phone-in show at the end of February. Good night, everyone.